Assalamualaikum warahmatullahi wabarakatuh and hi. Okay, firstly I want to introduce myself. Okay, my name is Raja Nur Atika Witra Jamat Sukri and my numerator is 2019295378. Okay, I'm the first presenter for our presentation group today, and I will present by introduction. Okay, first, HIbah is the main choice of property owners to distribute their property later. In addition, HIbah is one of the branch of property ownership that is accepted in the Islamic side and is considered a commission performed by the scholars. Okay. Second is HIbah is a gift that is done voluntarily in order to get closer to Allah SWT and without expecting any return. When a person gives his property to another person, it means that the giver is giving away his property. Because of that, the word grant has the same meaning as the term giving. Another thing to keep in mind is that the HIbah must be given to the recipient by property owner, which is giver, while he or she is still alive. As a result, the grant transaction is cash and direct, and the transfer should not be made or required to occur after the grantor's death. Okay, next is Muslim property planning is critical to ensure that the property process is properly administered and managed, especially after the death of the property owner. One of the aims of Islam, which is revealed as a blessing to all men, is to ensure to the long-term viability of the property acquired. As a result, Islamic law has offered numerous property management instruments to achieve that goal. Okay, and lastly is giving HIbah is also seen to help with the problem of claims settlement delays for the deceased estate. That means HIbah is viewed as a cost-effective alternative to property management that can develop love and reduce antagonism. Because the HIbah is immediately effective, it does not necessitate a lengthy process because it is implemented while the giver is still living. Okay, that's all for the introduction. So I will pass for the next presenter. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Akila binti Jasmi and my matric number 2019423436. Okay, today I would like to present about definition of HIbah. Okay, HIbah can be defined as an act of giving valuable goods without expecting any return from the person. It can also be concluded as a gift to fellow humans being and is highly encouraged in Islam to guarantee the maqasid syariah. Okay, it also can maintain our relationship and become more closer. Okay, the application of HIbah in Malaysia is applicable while the donor is still alive, and if the donor dies, the HIbah will be carried out conditionally. Okay. In Islam, we can call HIbah as a tabarruk contract, okay, which is a good deed done without having the opposite intention. Okay, the meaning of HIbah in Islamic terms is a good deed done to legally own property without using illegal way. However, the concept of HIbah is different from other Islamic property ownership concept. Okay, next I will explain about the pillar of HIbah. Okay, firstly we have Al-Wahid. Al-Wahid must enter into the contract without any coercion from any party and must be voluntary. The individual must also be someone who has reached puberty, sane, and most important, the property to be donated belongs to the giver entirely and not belong to others. Okay, second we have Al-Mawhub Lahu. Al-Mawhub Lahu is a recipient of the HIbah. It was encouraged for someone qualified to manage the property donate. If the hibah recipient is not property or not yet eligible, the property must be given to the individual's guardian. Okay. Thirdly, we have hibah property. Okay, the property must exist when the grant is made. It must also be a property that is halal and valuable from the Islamic point of view. Okay, lastly we have lafaz ijab and kabul. It was important to show that the grant and receipt of the hibah have been done. Okay, next I will explain about conditional hibah. Conditional hibah divided by two. Firstly, hibah al-umrah, and secondly is hibah al-rukhbah. Okay. Hibah al-umrah can be defined as the gift of property that is tied to the life span of both parties. Then, hibah al-umrah also is only for temporary. Okay, if the hibah recipient dies before the hibah giver, then automatically the hibah property will become the property of the hibah giver again. Okay, for example, this land I give, which is hibah, to you while you were alive, and if you die, then the property returns to me if I'm still alive, and to my highest if I have died. Okay, lastly, I will explain about hibah al-rukhbah. Hibah al-rukhbah is the gift that is tied to the day of both the giver and the recipient of hibah. Okay, to be more understand, the hibah property will belong to the hibah recipient if the hibah giver dies. But if the recipient die, the property will return to the giver. Okay, for example, I give this land to you as rukhbah, and if you die first, then the property returns to me, and if I die first, then the property is for you. That was the example sentence while doing the hibah al-rukhbah.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Nabil Ashraf bin Muhammad Kamal. Nombor matrik 2019475624. Okay, now we're going to the comparison of 4 mazhab about related to hibah. Okay, in this option, I was talk about hibah in condition, because in hibah mutlaq, that doesn't have many exclusion of between 4 mazhab. Okay, so we're going to the comparison of hibah in condition. Hibah in condition, the first thing is about definition of hibah. Okay, in Shafi'i scholar, definition of hibah is a hibah is a gift belonging to the ain harta without return while living voluntarily. Okay, this is from Shafi'i scholar. And then from the Hanbali scholar, is giving possession of a property while living without return voluntarily. This about in Hanbali scholar. And then the Maliki scholar is the give the definition is grant as a gift, grant or hibah as a gift of property when living without return. This from Maliki scholar. And then the last one is Hanafi scholar. The Hanafi scholar definition of hibah in the Hanafi scholar is gift of ain property without return. Between of 4 comparison, for this comparison is not the same, but okay, from 4 definition that I said early, what I want to say here is that from this definition, it doesn't make much difference between of Shafi'i, Maliki, Hanbali and Hanafi scholar. Now we're going to the next comparison. Okay, the law of hibah rukhbah. Actually, hibah rukhbah is under the hibah in condition, not hibah mutlaq. Okay, the law of hibah rukhbah, there they go. There are three scholars said that about the law of hibah rukhbah. The three of scholars said the same thing, which is hibah condition of rukhbah is the same as the law of hibah condition of umrah. So the hibah of the rukhbah condition is valid when it is not combined with the rukhbah condition. Okay. In hibah rukhbah, they have the rukhbah condition, but rukhbah condition is valid when it is not combined with the rukhbah condition. So the valid of hibah rukhbah is not using the rukhbah condition, so it is valid. This is from scholars Maliki, Hanbali and Shafi'i. Then they said valid of rukhbah, hibah rukhbah, but not cannot use the rukhbah condition. Now we're going to the law of hibah umrah. Hibah umrah, in this hibah umrah, there are three scholars that give their opinion, which is Shafi'i scholar, Hanbali scholar and Hanafi scholar. Okay, in these three scholars, they also give the same opinion about the law of hibah umrah. Hibah umrah, in these three scholars, they say hibah with the condition of umrah is valid, but the condition of umrah that apply void. We disqualified the condition of umrah. This is because when the hibah giver give a thing, money or anything to the recipient hibah, use the condition of umrah, so the recipient hibah can take the things immediately without the need for time or age. As we know, hibah umrah is the gift that is not permanent, by require that the hibah be given to the surviving party when the giver of the hibah dies. So to complete the hibah umrah, they must not use the condition of umrah. They batalkan condition of umrah. Okay, in this slide, we're going to continue of the comparison of four mazhab. Okay, now I'm going to tell you about the hukum ijab hibah on condition of consideration or replacement. This is the hukum hijab on consideration. So if you see in the table, the hukum of hijab in consideration or replacement is harus. So four scholars, they said the hibah on condition of consideration or replacement is harus. And then the comparison of in the condition of consideration or replacement, hibah condition, which is the type and form of the hakat hibah. Okay, in Shafi'i scholar, they said clearly stated the form of reply or replacement required, but the law is sale and purchase agreement. So the form of akad hibah must be clear, and must tell you what is the replacement that the hibah giver want to replace, want to get back. In the law of hibah akad must be is the sale and purchase agreement. It's going to be akad jual beli. And then in mazhab Hanbali, that clearly is in mazhab Hanbali, they going say the same thing with Shafi'i. So the Shafi'i and Hanbali said the akad of hibah must be clear and the law of akad hibah must be going replaced to the akad jual beli or akad sale and purchase. Okay, now we're going to the Maliki scholars. What Maliki scholars said about the type and form of hibah condition, consideration or replacement. Okay, they said the contract remains valid even if the type of consideration or replacement item is not explained as it is count as a sale and purchase agreement. So in Maliki scholars, that is okay when the akad hibah said clearly or not clearly. They also valid when the akad hibah said not clearly. But also when the beginning of akad hibah contract and until the end, it's count as a sale and purchase agreement. That is from Maliki scholars. That a bit different between Shafi'i and Hanbali. Okay, now for the last one is the Hanafi scholars. Hanafi scholars said the beginning as a akad hibah, but the end as a sale, as a sale and purchase agreement. The beginning of akad hibah, is count to the akad hibah agreement. But when the hibah giver finish a contract to the recipient hibah, it going to it's changed to the sale and purchase agreement. So from all the comparison that I studied in subject fiqh Quran, what I get is although the issue of grant with inviting condition varies opinion of fuqaha, but in theory we are not bound and can accept one of their opinion because the practice of hibah is not included in matters of faith, rather one from the practice of the non-destructive muamalat decree. So this is from me about the 4 comparison of mazhab about hibah.
Assalamualaikum Doctor and all my friends. Today I will present a little bit related to the objective 3, which is condition hibah in Malaysia. Before that, I would like to remind everyone that the meaning of condition hibah. Okay, it is that accompanied by condition or reward being the hibah contraction. However, it is not empty that we can put any condition we want. The condition we must be fasik. It is not a condition the fact of hibah, which is a voluntary giving. Okay, for everyone information, for the result of the grant of the hibah can strengthen the relationship between family member or member involved in the celebration of the hibah, because with the existence of this hibah can solve a problem such as the claim of the cases estate. Okay, the nature of hibah, the effective, immediate, does not require compliant process as it implies what the given is still alive. Okay, among the pillar of hibah that we can need to know is first grantor, second grand recipient, third donut good, third sirah, and we won't need to be emphasize is this condition hibah, which the application of the condition hibah is used in Malaysia, but the conditions of sirah presented by Jumhur Fuqaha. Okay, back to my objective, which is condition hibah used in Malaysia. I will explain the relationship to hibah in takaful and second, hibah in property. The first is hibah in takaful used in Malaysia, which is a concept under Islamic. There is own role and concept and is a contribute to the Islamic financial system in the modern era. Before this, the Islamic takaful system in Malaysia often experiences problems related to Islamic financing. So, from that problem, the takaful also use condition hibah in the takaful system. Okay, which in the takaful system, the concept of hibah has been applied in the product direct. Okay, first is family takaful as a way out of the family, as a way out to enable takaful benefit money to give to certain races according to the wishes of contribution without being subject to fara'id law, and will as explained in the Sharia resolution in Islamic financing by Bank Negara Malaysia. Okay, usually the problem often occur when the takaful owner died and the takaful period method. So, the takaful owner is given the option to put a name or to give a takaful benefit after the owner died. Okay, this is because the property is not made in the estate, and with the existence of the name system can avoid fight. Okay, apart from the takaful from the contributor, there are also education takaful plan. For the example, takaful practice plan, we donate takaful benefit to their children to finance their education costs in the takaful. If the takaful pretty part died, all the takaful benefit will become the named property, and the property will not distribute to other beneficiaries based on the fara'id. However, if the takaful critical is still alive when the takaful certificate matured, the benefit will be assigned to the takaful participant. The conclusion the conclusion I can make from this hibah is this takaful is the concept condition hibah, which is it means this condition hibah that is suspended on the date of the takaful principle. Okay, this is because in the event of any date of this takaful principle, that this hibah will be employment. So the hibah used in this situation is hibah with the condition the ru'bah defined as the granting of ownership of property to another person after that. The second is related to condition hibah in the extract of property when each of the person who own the property has a plan collecting the property, and they also have way to manage and protect the property. Okay, the main goal is ensure that the property owner can be advised in a good way, and there are any fight with each other. Okay, the second is to ensure that the estate of advisor according to correct guideline, whether it is devised according to the method of fara'id, hibah, will and so on. Okay, this is because the distribution of property by hibah does not need to go through the administrative process as requirement in application and settle of estate by fara'id. Okay, therefore there is not the problem in terms of delay and arrest of the property distribution case. Okay, if the property on use a condition grant as the instrument of administrative in the case, the legal property is not as mentioned. The grantor meant for example place a condition that he is still entitled to enjoy the process or use the property of the grant of as long as he is alive. Okay, similarly he can make the condition of ru'bah to deal with the situation of the child dead before him. Okay, in relationship to the adopt child, through hibah, through this property, and adult child can feel or get from the property owned by his adoptive family. Okay, this is because the adopt children is not mean in the health. I think that's all. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Ikram bin Azmi, matrix number 2019218782. And now it's my turn to discuss about HIbah issues in Malaysia. And I hope you all will take a note about what issues happen in Malaysia to make it as a lesson in our life. In this present, the first issue I want to explain is HIbah mortgage property. Among the issues that are often raised about the property that can be granted is the property that is not perfect owned by the grantor, whether it can be granted or not, such as property that is still in collateral or mortgage that is not perfect owned by the grantor, or property that is still in financing. So in Islam, property ownership divided into two methods of property. First is perfect ownership or milk al-tam. Second is the imperfect ownership or milk al-nakis. Through this perfect ownership, milk al-tam, the right and freedom is given to the owner to do any dealings or tasarruf on the property he owns, while the property under the ownership of milk al-nakis or imperfect ownership, the right is limited and depends on certain conditions. So, based on the view of the fuqaha, who is free of hibah on the property belonging to others, then a property belongs to the powerful giver. Its ownership is imperfect, may also be granted, subject to the permission of the party having an interest in the property. Permission from the parties is obtained through sulh, ibrak, daman or takaful between creditors and property debtors. The view of the Maliki and Hanafi sects that requires the granting of hibah to the property that is not absolutely owned by the giver, provided the consent of the owner of the property. Then it is appropriate to allow the hibah of property that is still in collateral based on the principle of maslahah and jurisprudence, which states that a difficulty can lead to convenience. So their views have been applied by the Kuala Terengganu Syariah High Court regarding the case of Raihana binti Muhammad Ali versus Kamaruddin bin Muhammad Noor and others in 2008. So the court dismissed the plaintiff's application to confirm the hibah made by his brother, the dad, on her, that there was no evidence to show that the deceased had sought permission from financier of the BBA scheme by Bitaman Ajil to enable him to grant the property to the plaintiff. The court in this case recognizes that property purchased through a BBA scheme and the like is valid provided it obtains the prior consent of the provider of the scheme or loan. The second point I want to explain in this issue is hibah the entire property. Grants or hibah are different when compared to other property management in Islam, such as will and fara'id. The rate of property that can be willed by the testator, according to the provisions of Islamic law, only 1/3 of the net property left at the time of his death after being used for his funeral expenses and settlement of debts, if any other testator's liability. Fara'id, the division of property is according to the rates that have been determined to only the eligible heirs, as found in the evidence in Quran and Hadith. True hibah qada or limit for the property to be hibah is not set. So the owner is free to grant the property owned according to what is desired. This is because the property to be donated belongs to the hibah giver. So it is up to the hibah giver to consider the rate of the property to be donated. Jumhur ulama, including Imam Hanafi, Imam Maliki and Imam Shafi'i, argues that it is sunnah equates a gift between children, and a gift that is more to one of them is unlawful, even if the gift is valid. According to the Hanbali sects, justice in the granting of hibah to children is an obligatory matter, that is wajib. The Kelantan Syariah Court of Appeal ruled that the hibah to the children is valid even if some of them do not get hibah, according to the case of Muhammad bin Awang and others versus Awang bin Duraman and others in 2001. In this case, the appeal panel is of the view that the law of generalizing giving to children is sunnah only and doesn't invalidate the hibah if some of the children do not receive the hibah. Donated 2 plots of land belonging to him to the second and third respondents, that is his children. After the death of the respondent, the appellants, who are the other children of the deceased, disputed the validity of the hibah to her, that the division was unfair because it was made unequally. So the Court of Appeal ruled that the hibah, although seemingly unfair, was a valid one in the law. The third point of issues is withdrawal or cancellation of hibah. When a hibah contract is perfected by fulfilling its pillars and conditions as well as the delivery and receipt of goods al-qab, then the property becomes the property of the hibah recipient even without the written iwad. This matter, according to the Hanafi school of thought, the giver of hibah can but makruh withdraw the hibah that has been given, and he can cancel the hibah even if there has been surrender or qab, unless the hibah is made in written iwad. According to the opinion of the Shafi'i, Hanbali and some fuqaha of the Maliki school, the withdrawal of hibah can take place with mere consent and acceptance, but when accompanied by the delivery and receipt of goods al-qab, then the hibah cannot be withdrawn except the hibah made by the father, or including also the mother, grandfather, grandmother and other proposals or related to his children, as long as the property is irrelevant with someone else. Then about the opinion of Imam Ahmad and Zahiri sets, the giver of hibah haram withdraw the hibah that has been made except the hibah of the father, also including the mother, grandfather, grandmother and other proposals or relating to his children. This is based on the hadith of Rasulullah SAW, which means a person who withdraws his hibah is like a dog who eats back his vomit. Hadith narrated by Al-Bukhari and Muslims. Through the facts in the case of Aisha binti Abdul Rahman versus Azuha bin Ismail in 1997, the plaintiff was the adoptive mother of the defendant and had given a piece of land to the defendant in the hope that the defendant would take care of and assist the plaintiff during life. However, after the transfer of ownership of the land to the defendant had neglected the welfare of the plaintiff. Therefore, the plaintiff filed a claim for the land grant to be withdrawn to settle the plaintiff's debt and financing the plaintiff's expenses to Mecca. Nevertheless, the court judge had to dismiss the plaintiff's application because the defendant's ownership of the land was legally valid and had met the tenets and conditions of the hibah. So this case shows the importance of adopting a conditional hibah, and that the rights and welfare of the hibah giver can still be preserved. That's all from me. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you for your all attentions.
Hi, me again. Okay, this time I present about the conclusion. Okay, first, hibah must be performed in conformity with the conditions set forth by Islamic law. That means it cannot be used to get around an Islamic rule, such as avoiding faraid property distribution or denying the rights of specific heirs owing to envy, revenge, or other factors. Hibah is commanded in order to provide Muslim with the opportunity to do as much good as possible in order to meet the divine. As a result, a Muslim as a whole should make the best use of it, because every single action taken by a mukallaf is based on his intention. Okay, second is hibah with the condition of umrah is related to age, which is the condition when the age of a giver of this hibah is his. That means umrah is a gift of property or benefit for a property by placing the recipient or giver's age above that of the giver. Okay, next is in another way, the fuqaha hold that hibah with the conditions of umrah can be done, but the condition of umrah cannot be used. This is because the property donated will only return to the giver after death. Okay, next is hibah with the condition of consideration means the grant of title to property associated with a replacement or consideration of the effect of such grant. According to Mazhab Maliki, a hibah contract remains valid even if the contract is unclear about the type of reply to be replaced. Contract with the condition of return or replacement is counted as a sale and purchase contract from the beginning to the end, and the hibah contract. This group requires that the replacement is paid by the recipient in return until the grantor knows that the grant has been repaid. Okay, that's all from our presentation today. Thank you.